Very good morning to you all. So we are in our fourth session, and the fourth session is on critique of trial and sentencing process in criminal law. So without taking much time, I would like to invite our first speaker. So what we will do that we will take the presentations of all, and after that we'll discuss the theme. So let's first try to understand what exactly the ideas which wanted to bring by the presenters, and then we'll discuss the same with the help of your participation as well. So with this, we will be able to have more participation and more participative discussion as well. So this is Dr. Sophie. May I request you to start?
A very good morning to all of you. Thanks to the organizers for this opportunity to speak in this conference. The title of my presentation is Misuse of Law by Women and SCSTs, a Counter-Narrative by Judiciary. I have a paper ready, so I'll be reading out the paper primarily. The recent judgments on 498A and SEC Prevention of Atrocities Act invited criticism for lack of gender and caste sensitivity and historical erosion of outlook of judiciary towards the social realities in Indian society. Both the judgments, Rajesh Sharma versus State of UP and Dr. Subhash Kashinath Mahajan versus State of Maharashtra, authored by the same judges, raised the concern about the misuse of law and false implications under the law, reiterating the hegemonic construct of patriarchy and casteism. However, the subsequent review petitions had different outcome. In the review petition on POA, Prevention of Atrocity Act, decided by the same bench, declined to review the dilution of SCST Act reiterated by the Supreme Court. However, on Section 498A, the Supreme Court clarified its position, disagreeing with Rajesh Sharma's case. The attempt in this paper is majorly is to look at the selective silencing resorted to by judiciary, especially the higher judiciary, by using the canvas of misuse against Dalits and women. We know that protectionist laws for both women and Dalits are formulated to assist both the sections in struggle against the discriminatory word. While the former fights against the various forms of patriarchy and gender discrimination, the latter fights against the caste system and its discriminatory attributes. Though the forms of discriminations are different, the lived experiences, history of discrimination, resistance, the history of movements against discrimination, etc. are different, but there are certain similar elements of oppression, rigidity, and limitations on accessibility, which invites social justice paradigm to intervene, which has been established, well explained under the Constitution, under the fabric of Constitution. Even in the discourse of development, it has been recognized that the discrimination and torture amounts to even intervenes with the productivity of human beings, productivity of both men and women. So it's important to intervene, it's important for the state to intervene with human rights of both men and women. And these protectionist laws were formulated recognizing the importance of the state to intervene in when discrimination and torture results in undignified social existence and affects their productivity. Yeah, very quickly I'll be dealing with analysis of cases, especially two cases that we are dealing with today. One is Rajesh Sharma versus State of UP, and the other one is Dr. Subhash's case. These judgments invites rereading for the reason that there is ignorance towards history and objectives with which these laws were framed. Both the judgments refer to right to liberty of the accused in a very considerate way. While dealing with the rights of the accused, the court in Dr. Subar's case resonates it with procedural and substantive arguments. The procedural reasoning revolves around how arrest without primary investigation and denial of benefit under Section 438 of Criminal Procedure Code under Section 18 of Prevention of Atrocities Act violates right to liberty under Article 21 of the Constitution. So it basically talks about explicit exclusion of application of 438 under Section 18 of POA Act. And the court very vehemently relies on this section to state that this Section 18 of POA violates Article 21 of the accused. The substantive grounds cover concept of secularism, vice of casteism perpetrated by POA, judicial function to uphold individual justice, misuse of law, caste-based crimes, and rights of the accused. The court mentions in the judgment that working of the POA should not result in perpetuating casteism, which can have adverse impact on integration of the society and the constitutional values. There is attempt to define how caste-based divisions would destroy secularism, a basic feature of the Constitution. The wrong premise on which the court has started its admonition brings forth an understanding that secularism is all about creation of casteless and homogeneous society, ignoring the identity and equity in a pluralistic society. The concept of secularism under the preamble has to be read along with all fundamental freedoms against discrimination mentioned in Part 3 of the Constitution. Caste-based discrimination is a social reality, and all legal reforms on protectionist laws for Dalits aimed at assisting them to assert their identity and lead a respectful and dignified life like any citizen. The interpretation that secularism emphasizes on casteless society is equal to ignoring the continuing history of discrimination, especially in the context of increasing hate crimes against Dalits tribals today. There is a writing by Anand Teltumbe on History of Prevention of Atrocities Act. And he writes that Prevention of Atrocities Act is enacted recognizing not only physical violence but also the social setting that encourages violence on the community. The cases filed by Dalits against perpetrators have been treated with this objective, and any violence or creating a setting that encourages violence is addressed under the POA. The comment of the court that POA perpetuates casteism has exposed not only the historical outlook of the judiciary but also embracement of the rhetoric of immaturity that the dominant society has attached with the Dalits tribals to exploit, oppress, and to undermine their self-determinism. This is judicial ranting of dominant narrative reverse casteism on account of no substance, but definitely adverse impact on rights of the Dalits. The rights achieved after long battle are brought under the shadow by counter-narrative of casteism by dominant judiciary. The court has also relied on right to liberty of the accused in this particular case. The whim of another that's indicated in this particular judgment actually talks about the complainant's malicious desire to put the accused through rigors of the law. Such a judgment against character of the complainant and using such a hypothetical argument to generalize the behavior of communities is unwarranted from the court of law. Court went beyond its balanced mind by declaring the accused non-guilty and innocent. The court brought in substantive argument of violation of right to liberty in this case and raised the criminal appeal to the level of writ petition by iterating violation of Article 21 of the Constitution, which was not the plea in this particular criminal appeal by the accused. The court uses the argument of liberty of the accused against the Dalits under the ground of misuse of law. The reality has come out in different studies pointing out how police prefers to report cases under Protection of Civil Rights Act rather than filing cases under POA in order to avoid complexity of procedures under the POA Act. Lack of implementation of law, speedy disposal, partiality from the part of the police, fear at the hands of dominant caste, and withdrawal or settlement of cases in the pretext of fear contributes to affecting the morale of Dalits in pursuing cases. And we see a lot of acquittals in cases under POA. And court exactly uses the statistics to state that the increased number of acquittal indicates misuse of law or false implications under the law. Can we read statistics, acquittal statistics, to denote misuse of law, especially in cases relating to SCSTs? There are many reasons. There are multiple factors that results in acquittal of cases under SCST enactment. The factors can be sociological, economical, political, and anthropological. Generally, lack of financial resources, lack of technological understanding of law, lack of social communication skills to interact with people in power, differential discriminatory treatment at the hands of enforcement machinery, etc. deter Dalits from pursuing their cases before the court of law. Therefore, large number of genuine cases fail before the court of law and results in acquittal. And this has been studied by Sabir Khora, one of the eminent academician who has studied final reports relating to Section 498A and Prevention of Atrocities Act in detail. When we quickly run through the case of Rajesh Sharma, the court uses the same rhetoric of misuse, even to state that women are not the best decision maker for themselves. Even the court mentions that filing a case under Section 498A breaks the possibility for reconciliation within the family. This remark actually reminds us a particular incident that happened in 1995, where Justice M.L. Pense, while giving an oration in Bombay University, mentioned about misuse of law by women. Against his oration, there was a huge protest from the part of the women, and Flavia Agnes wrote a huge letter talking about the approach of or attitude of police while dealing with cases relating to women. And even in 1995, the major protest was against how the dominant judiciary or judges can talk about statistics relating to acquittal, especially in the context of women's rights. The acquittal cases cannot be, the statistics relating to acquittal cannot be considered as a reliable source to indicate that it's because of misuse or false cases that majority of the cases results in acquittal. Even though the discussion started on 1995, even now this discussion still continues before the higher judiciary. That's what we see in Rajesh Sharma's case. Even the court relies on the statistics to state that acquittal indicates false cases, which is not true. Because there are a lot of sociological, economical and political reasons why women don't pursue their cases further. Yeah. While reading these cases, it's very important to look at how Constitution treats both women and Dalits. We know that under Article 15.3 and 15.4, special status has been given to women and Dalits. And the Constitution enables the state to make protectionist laws for empowerment of women and Dalits. And these laws have both POA and Section 498A have been formulated with the intention to empower weaker sections in the society, women and Dalits. And these laws, which were considered as protectionist laws, are being used as a counter against women and Dalits currently, even by the judiciary. So the popular narrative that women and Dalits misuse law is being iterated by judiciary, dominant judiciary. This is not a good precedent for the society to follow. highly unwarranted in the current socio-cultural context and reporting of increased crime rates against Dalits. The low level of conviction rates is not because of falsely implicated cases. There are factors which are sociological, political, economic, cultural and hegemonic reasons for non-persuasion of cases by the victims. The prevailing discourse of misuse refuses to look at life and the situation that these weaker sections, both women and Dalits, face by invoking protection under protectionist laws. The last nail is hammered by reiterating this discourse by the higher judiciary. The monistic lens of assessing functionality of law based on rigid reading of statistics without considering its social, political, historical and economic underpinnings would dilute policies for social justice. Yeah, thank you. Thanks for listening.
Thank you, Dr. Sophie. In her presentation, she emphasized on that Dalits and women are from vulnerable group. They are from the weaker sections, and it means what I feel that the Dalit and women, their movement is for mainly for right to self-determination. However, each coin has two sides. So if whatever the protection regime is developed for the protection of Dalit and women, so there is use, but however we cannot deny that yes, there is misuse also. However, before diluting any kind of policy regarding protection regime, we should not forget that Dalits and women, they are still vulnerable. In fact, for dilution of any kind of policy, which is developed because of the long history as also the reality of a society, some empirical research should be done rather than diluting a policy just because of one or two cases. So this is what Dr. Sophie, she tried to say during her presentation. The point or the suggestion of empirical research was from my side. So thank you so much, Dr. Sophie. Now the next presenter is, yes, please come. Your name is Charna Elsa Philip. She is assistant professor from School of Legal Studies, and she will be speaking on emergence of critical perspectives in criminal law. Yes.
Respected chair, panelists, other speakers and friends. A very good morning. Now, the topic that I'm going to speak to you, I don't have a PowerPoint, okay? The topic that I'm going to speak to you is slightly delicate because I know I'm standing within the campus of National Law School, Delhi. I will be touching death penalty. Now, you know that, there have been enough and more discussions on whether we need to abolish, whether we need to retain. There's been empirical studies. I will not be talking on the numbers. I will not be arguing on whether you need death penalty or not. No. Abolition, should be abolished, should be retained? No. I'm not touching that. But most of us would have come across a particular statement in most of the studies that I've done which says that death penalty does not deter anymore. Death penalty has lost its effect of deterrence. It will not deter anymore. Actually, this particular sentence provoked me to think in a particular view, to understand what do you actually mean by deterrence. Okay? Now, if you remember yesterday, Bajpayee sir was speaking about criminal justice administration when he said it is theory and functional. Theory versus functional. So I just wanted to touch the theory part and just and just try to bring to you all when the theory is there, shouldn't the functioning also happen simultaneously? I would be, within my humble knowledge, I would be just trying to show you what actually the theory is and how is it functioning. To start with that, so I will have to just tell you what deterrence is. You all know what is deterrence. Any punishment that when you say from all our criminal law teachers have been telling us IPC is deterrent, IPC is deterrent. What's actually deterrence? Deterrence, to you and me, what is deterrence? When any particular person contemplates a crime and he is about to do that, he is stopped. Why? The legal consequences looks at him and says, don't do it. You do it, you're done with it. So I'm scared and I pull myself back. Yes, this is what we have understood. Now, these theories are actually based on certain assumptions. In the 18th century itself, Beccaria, then Jeremy Bentham, all these people have studied. They were all utilitarians and reformers who tried to study these concepts and tried to bring this out. So now what they told us, now according to them, the theory is based on an assumption. You know what the assumption is? One, deterrence theory is based on the assumption of surety, certainty, severity. Surety, one, swiftness and severity. That is, the punishments have to be severe. When the punishments have to be severe, don't forget, they also have to be certain. Because if it is a severe punishment and if you're not putting it on me, there is no certainty in it, you can't deter me. So there has to be a there has to be a severity. Second, there has to be a certainty. And third, that surety and certainty goes together only when it is swift. This is actually the theory of deterrence. These are one of the basic assumptions on which the theory lies. That's the theory part. Like how Sir said yesterday, let's pull it to the functional part. Who has to function this? The theory doesn't come and function. It's the criminal justice administration which needs to function. Is the administration working? I would like to ask a question to myself. Is the administration functioning in such a way that these punishments are severe? Even if they are severe, okay, let's take it severe. Is it certain? Are we sure? Is it certain? Third of all these, like how Bakshi Sir said yesterday, delay. Is it swift? These are the questions that we want to ask, and this is where we will have to, this is the critical perspective. So then to me, I felt, every time when I say, yeah, death penalty doesn't get it, that is wrong. Because deterrence is something else, and we are not practicing it. And what it actually says is, the moment you add a variable, the moment you add a variant to the theory loses its character. What are the variants? Because I'm taking up death penalty, what are the variants? Mitigating factors, aggravating factors. We started from Bhajan Singh wherein they said rarest of rare case. Now when you're coming to Santosh Barrier, it's not only rarest. Crime test, criminal test, rarest of rare. All these are the factors variants which we have added. The justice administration has added. So I felt, I don't know how far I'm true, I don't know how far I'm right, but then I felt the actual deterrence theory still holds good. The theory holds good, but it is a functional part. So it wouldn't be right for us to look at the theory and say, theory, no, you're not good at all. That wouldn't be right, because that is not what is being intended. One. Now let's come to the functional part. Now when you come to the criminal justice system, like enough and more cases we have. We'll have to start from 1980 or even before that, 2 years before that, wherein we started with Rajendra Prasad, wherein that is not needed because every one of us know about it. I would like to bring out a couple of decisions. One of the most important decisions, like Swami Shraddhananda's case. You know what the court said there? When the person killed and he was found out and all those things, the court said, yeah, it is a case to be given death penalty. We have to give. But you know what the problem is? I can't give death penalty because there is particular rule is not there. Let's see where the disparity and discrimination is happening. Whereas, where there is another case, Vikram Singh's case. A child who was 14 years was kidnapped and killed. You know what the court said there? The only son was kidnapped and killed. No, give death penalty. Wherein a child who was 1 year, 1.5 years, 6 months, you have been in more rape cases. Wherein a mentally retarded child was raped by your own uncle, the court said, no, we can think about reformation, it is a kind of psychological problem. We have no issues taking it up. But then why this disparity? Alright, the watchdog, the whole nation looks upon you. We don't now anymore believe in executive, like from whatever has been discussed with regard to the police, the custody, how it is getting misused. Okay, we don't want the executive. The legislature, you are not even waking up. In spite of you're supposed to make so many laws, you're not even waking up. And whenever you are making up, yesterday we understand that it is in 1 hour, 1.5 hours, whenever you want, you make a law. To your whims and caprice. But then there is one ultimate institution that we look upon, and that's always the judiciary. I really feel that judiciary, it is high time that you wake up. Or, being academicians, being practitioners in law, we should help them out. Now that's why I'm here. How do we help them out? With great due respect to Lord Macaulay, we look at him, we say, wow, one of the best statutes that's ever happened. No doubts, offences have been mentioned. The ingredients for the offences are perfect. No issues. We are okay with it. But punishments? Now when you say punishments, yesterday we spoke about reformation, we spoke about community sentencing, we were speaking about Salman Khan to be given a community sentencing. Do we actually think that India is going to go ahead with all this? I'm happy at least got 5 years. He would not have given community sentencing, he would not have paid a penny. At least 5 years, let him be a convict. You understand? The thing is, we are not, when we speak about big things, even yesterday we spoke about restorative justice. Are we in a position, in a restorative justice, when it is a man who's killed and he doesn't have the means to pay back to the victim? Who should pay? The state should pay. Are we in a position? Is the state in a position? We are not. So when we speak, those are things which are far-fetched for us. Like how, there should come a situation where there will not be criminal, the Ethiopian society where you're not speaking about any kind of crime. Then that's fine. Somewhere in the near future, we don't even think about it. Day by day, crimes are increasing. Laws are coming up, the crimes are increasing. So that means the way we are performing it, the way that is being administered is what is getting wrong. So what I actually personally felt was, now the IPC is given. So we don't have issues with offense, like how I already told you. We don't have issues with the ingredients. Yeah, all that is perfect. But then with regard to punishments, I don't know how many of you would have come across that mischief part, offences against the property. You know what the fine is? 10 rupees, 20 rupees, 50 rupees. How much are you paying for a pack of Lays here? Do you get it? If you're not even bothered, our kids, the generation that is growing up doesn't even know the value of money and is speaking about 50 rupees and 10 rupees. So I really feel that there is high time that we rethink about the punishments. I'm okay with all the reformation that you're speaking about. We have. Our laws are good enough for that. We have the Probation of Offenders Act. How many of us know? Do you know? I don't remember the judgment, but then when Judge Krishnaiyer said that probation of offenders is there, but no judge knows it. Even if they know that, they don't know how to put it into effect. When it was made in 1958. And justice is coming and saying, we don't even know how to put it into effect. Most of the judges don't know about it. So then what kind of reformation are we speaking about? Reformation is there. It has been there. The provisions in the CRPC are telling us about reformation. Juvenile Justice Act tells about reformation. That's why we are not punishing. All these are there. Then what are we again and again speaking about? So there is something, there is a concept for punishment. The purpose of punishment is totally different. With all this, then with due respect to the reformative theory, with due respect to the community sentence, with due respect to the justice to both the victim and the offender, are we all ready to take a situation wherein an offender is let loose with no punishment? If the society is ready, even I am okay with it. The society is never ready. We will not be ready. The victim always looks upon. I don't know, 2-3 days back, now even recently, the Rajiv Gandhi assassin, even before coming to that, let me tell you something. Now, this is how it is going on, okay, with regard to the punishment. I would also like to bring to your notice, now so Shraddhananda says, Vikram Singh says, okay now, and Santosh Barya finally said, please refer the matter to a law commission report. We are not touching it because everything is in hangama, arbitrariness, Article 14, we are not touching. Okay, don't touch. That penalty is gone, finally, go. Though in books, done. Adding to the now legislations, Madhya Pradesh, Haryana, Rajasthan, all have made up laws. Minor below 12 years, if you are raping, one option is death penalty. Why? When the law commission report says we want to abolish it, why are we abolishing it? 140 countries abolish, so we also abolish. Second, why are we abolishing it? There is delay. Whose fault is the delay? Our fault. Are we washing our hands of saying, no, there is delay, it is delay. Now see, then I wanted to tell you about how the judiciary is going abroad. Now, Beccaria said, the power to make laws with the legislature. Judiciary, you only interpret it. You don't have the authority to make law. If you make law, you will not be able to maintain uniformity. There will be disparity, which will end up in utter chaos. And I would say that's exactly what is happening now. He told it in 18th century. We would probably say that will not work now. Yeah, that's fine. It doesn't work now. But then let's see what the chaos is that's happening. If you have come across the latest decision, Sriharan versus Union of India, that 2016-17 decisions, wherein, you know what the court said? Court said, okay, give him life imprisonment without remission. What is without remission? 432, with the power of the executive. The legislature has made a law saying, remit when you feel it's an act case. Judiciary, who are you to interfere and say not to remit? Are you rewriting the CRPC? If you ask an LLB student, what is life imprisonment? You know what he'll say? 14 years. Is it? Thanks to 433A. Otherwise, if you kill, you could have, there was a situation where you can come out in 5 years also. That's when 433A came. At least 14 years, sir, be in jail. So that they are stopped there. You understood? So thereby, the legislature has got a purpose. They're not forgetting that. Now, judiciary, when you go ahead, you need to stop somewhere. You interpret it. Now you go for life imprisonment till death for 25 years. Now, that is when this Rajiv Gandhi assassin Pereri Verin. Now, his mother had put up a petition 3 days back and that was rejected. She wanted a remission. So the state government was okay with it. The central government said, no, you can't remit it. So she said, you better kill us. Kill him. Now she's put a petition for euthanasia, mercifully. Why should he be in jail? You won't allow us that way?
Last 1 minute.
Yeah.
Will it be okay?
Done.
Yeah.
You don't allow them to do that. Neither are you allowing it here. You can't be. So are we moving on to a situation where none of these punishments should be applicable? And even when it is applicable, you're not allowing us to comply with it. So I really feel that punishment, there should be a whole revamp on the punishments. Like how sir said yesterday, offences against state and offences against human body. What difference does it make? Because we are taught that a crime is against the society, against the state. If it is against the state, you cannot distinguish between offence against state and offence against human body. It is not only when you put a bomb towards a pillar of parliament, it is also when you attack me, it's an offence against the state. So I basically feel that these offences, the tag of different kinds of offences have to be pulled up, and serious offences and punishments should be based on punishments. Second, the disparity that is given, 6 months to 3 years, 3 months to 2 years. What kind of a disparity is that which will end up in discrimination, giving the judge that subjective matter? That has to be reduced. That has to be. So we need to make, the legislature has to be more specific in telling these things as to what kind of punishments and what can be the maximum. There should be a minimum in where the judge is given the opportunity to exercise this disparity. So unless and until that is done, whether it be capital punishment, whether it be life imprisonment, this issue of disparity and discrimination will be ruining the criminal jurisprudence. Thank you.